Case number 24-CR48, State of Ohio versus Dylan Rogers. Present for the state's prosecuting attorney Annika Collins. Present for the defendant's attorney J.D. Wagner. And are you Dylan Rogers?
Yes, Your Honor.
All right. The defendant's been in charge with in a 12-count indictment with various offenses, including receiving and drug offenses. The matter was set for a plea yesterday, and then the court continued it until today on its own motion. And Ms. Collins has the alleged victims of the receiving stolen property offenses been notified of the time, place, purpose of the hearing, and right to be heard.
And we were able to make contact with all three. Two of them are present in the courtroom today.
All right, thank you. All right, now, Mr. Rogers, I've been presented with a plea of guilty form, which indicates you're going to plead guilty to counts 1, 2, 3, 9, and 11. And this is I think this one is 4 pages in length. And on page 3 at the bottom of the page, there's a sentence that reads, I enter this plea voluntarily. Immediately below that are signature lines, and I'm looking at what appears to be signature of Dylan Rogers. Did you sign this agreement?
Yes, Your Honor.
When did you sign it?
Last week? Yeah, last week, I think. Friday.
All right. And when you signed it, did you understand that it was an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And did you have your attorney go over this, explain everything to you, and answer any questions you had before you signed it?
Yes, he did.
And since it's been a few days ago, is this still what you want to do?
Yeah, he was just questioning, there was I think it reflects, Your Honor, on the plea recommendation that there's an amendment. I think it does reflect on here, Mr. King made the amendment yesterday, as opposed to 5 years, it would be 4 years and 11 months. To make him eligible for judicial after 1 year. He just wanted to make
Yeah,
sure.
59 months is what I'm looking at.
Yes, Your Honor.
Yeah,
He
okay.
just wanted to make sure.
Yeah. All right. And are you, did you sign this agreement voluntarily and are you going forward today voluntarily?
Yes, Your Honor.
All right, now the agreement states that you're going to plead guilty to counts 1, 2, 3, 9, and 11. Counts 1, 2, and 11 are each receiving stolen property under 2913.51 of the revised code, 4-3 felonies. Count 3 is trafficking of marijuana. That's a third-degree felony, and there's a forfeiture specification. The receiving stolen property is 2913.51A, the revised code. Trafficking is 2925.03A2, the revised code. And the forfeiture is under 2941.14.17 of the revised code. Now, on page 1, it indicates that you understand that the potential penalties for counts 1, 2, and 11 are 6 to 18 months in each count and a fine of $5,000. On count 3, there's a possible penalty of between 9 and 36 months incarceration, maximum fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. And there's a presumption of prison should be imposed on that, but it's not mandatory. You understand that?
Yes, Your Honor.
All right. And so if you are convicted of all offenses and sentenced to serve them consecutively, meaning one after the other, the maximum possible penalty then would be, looks like 54 and 36 months is 90 months. So that apparently, I think that is 8 years and 4 months, if my math is right. Is it? Does anybody know? Yeah, it's in the file now. Okay, that's about a 50-50 chance. And there's also a possible fine of $25,000. You understand all that?
Yes, Your Honor.
Now, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No. No, sir.
Now, under the law, if you're convicted of these offenses and sentenced to prison, upon the completion of that prison term, the adult parole authority under the law may exercise the option to put you under post-release control for a period of up to 2 years. They don't have to, but they can. But if they do, then you'll be supervised under the conditions they set by a parole officer, and if they determine during that period of time that you have not complied, they can return you to prison even though you serve the entire term set by the court for an additional period of up to 9 months for any single violation, but there is a cap or limit of half of whatever your prison term was for all violations. However, if you commit a new felony, then in addition, whatever sentence could be imposed in that new case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. You understand that?
Yes, Your Honor.
Now, under the law, these are not mandatory prison terms. There's a presumption on the trafficking charge that there should be a prison term, but it's not mandatory. And so that means that you could be placed, instead of being sent to prison, on community control or probation for a period of up to 5 years under terms set by the court. If during the period of time you were being supervised, probation felt that you were not complying, they would have to file a written notice out with the court and give you a copy. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of the hearing was that you'd failed to comply, then at that time the court could revoke your community control and sentence you to a period of 90 months and fine you $25,000. And if your revocation was due to committing a new felony case, then and you received a prison term in that new felony case, that term could be ordered to be served consecutive to the term in this case. Do you understand that?
Yes, Your Honor.
All right. Now, starting with count 1, that charge reads that on or about June 1, 2023 through July 13, 2023 in Highland County, Ohio, that you and Caitlin Rogers did receive, retain, or dispose of certain property, being a 2020 Chevrolet Equinox and motor vehicles defined in ORC 4510.01, the property of V1, and that you and Ms. Rogers knew or had reasonable cause to believe it had been obtained through the commission of a theft offense. Violation section 2913.51 of the revised code. Count 2 alleges the same offense and the same date and the same elements, except it is a 1998 Honda Civic allegedly belonging to a V2. Otherwise, it's the same offense and the same language. Count 11 alleges that on or about the same date in Highland County that you received, retained, or disposed of a 1990 CRX, which would be the property of V3, otherwise the same language. Now, count 3 alleges that on or about July 13, 2023 in this county, you and Caitlin Rogers did prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute marijuana, a Schedule I controlled substance, an amount equal to or exceeding 200 grams but less than 1,000 grams, when you knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by the offenders or another person, and violation 2925.03A2. So that's the charge of trafficking in marijuana. And then count 9 is a forfeiture specification, and it alleges that you, on or about July 13, 2023, in Highland County, Ohio, that you and Caitlin Rogers had in your possession following properties and property subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in ORC 2941.14.17. There are 12 items listed there. Item 1, 2, 3, 5, 4, 5, 6, 7, and 8 are all firearms. 9 is 12 rounds of .32 auto ammunition. 10 is a box of miscellaneous ammunition. 11 is a box of miscellaneous firearm magazines. And then 12 is a real estate located at 211 South Railroad Street in Leesburg, Ohio, 45135, and a parcel number of 1702110038.00. And that doesn't carry a fine or a jail sentence, but it results in the loss of that property or any interest that you have in that property to the state. You understand all of that?
Yes, Your Honor.
All right. Now, Mr. Rogers, do you understand what you've been charged with in each count that I just read to you, what the state said you did, when, where, and how they alleged you did it?
Yes, sir, I understand.
And have you discussed the nature of the charges, the evidence in the case, the possible legal issues in the case, possible defenses you could try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir, Your Honor.
Have any threats been made to make you plead guilty?
No, sir.
Now, on page 2, going on to page 3, there are a number of lines that are printed in bold and underlined, and I'll read those into the record at this time. Defendant will enter a plea of guilty to count 1, count 2, count 3, count 9, and count 11. State will dismiss remaining counts. State and defense jointly recommend 11 months incarceration on count 1, consecutive to 12 months incarceration on count 2, consecutive to 24 months incarceration on count 3, consecutive to 12 months incarceration on count 11, for a total of incarceration of 59 months. I will note that the 59 is written in ink, and the 11 is written in ink as well, and that was changed by counsel. Is that correct?
Yes, sir, Your Honor.
All right. Continuing, state will not oppose judicial release to substance abuse treatment after 12 months incarceration. Defendant agrees to forfeiture outlined in count 9. Defendant agrees to make restitution to V1 in the amount of $762.49, jointly and several with Caitlin Rogers. He may agree to make restitution to V2 in the amount of $1,019.34, and joint and several with Caitlin Rogers, and agrees to make full restitution to all victims. That would only leave count 11, wouldn't it?
It would, but you don't know what the
You don't know
rest
what that is. Okay. There's no been a claim for it.
is.
All right. Now, is that your understanding of the agreement that you've entered into with the state of Ohio?
Yes, sir, it is.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, sir, they have.
Under the law, Mr. Rogers, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement recommending specific sentences on each of these offenses, other than count 9, that's not binding on the court. So if you plead guilty, I don't have to follow that recommendation. I could decide that that's not the correct sentence, and I could give you a sentence greater than that or lesser than that, depending upon what I believe is the correct thing to do. Do you understand that?
Yes, Your Honor.
Likewise, the matter of joint release, judicial release, if you're sentenced to prison, is not on the parties. It's up to the court. And so there's an agreement that if you are sentenced to prison, that the state would not oppose a motion for judicial release after you serve 12 months. Again, that's not binding on the court. I'll make my mind up based upon what the information is at the time it's submitted. And so just because the state says they're not opposing it, doesn't mean it's going to be granted automatically. You understand that?
Yes, sir.
All right, now, do you hold any kind of license or certification from the state of Ohio for any from any government entity that regulates any occupational profession?
No, sir, I do not.
Right, and you have certain constitutional rights, you must understand, before I can accept a plea from you of guilty. First of all, you have a right to have counsel. Mr. Wagner was appointed to represent you. His appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you'd like him to provide. So if you decide you do not want to do this, that you would rather defend against the charge, he will continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial on these charges, which means that 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented. They'd be instructed on the law. And then that jury of 12 people would have to decide by unanimous verdict, meaning all 12 would have to agree as to whether the state proved your guilt on each of the offenses. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing your right to have a jury trial. And that means that instead of having a jury trial, you would then be tried by a judge who would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt on any of the charges. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses have to come into court and testify in public in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in or can come in voluntarily, at your request, the court will issue a court order, that's a subpoena, to those people. And that would force them to come to court to be available to testify on your behalf if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that? All right, now, Mr. Rogers, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. Prosecutor can't, the judge can't, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one's even allowed to comment about that, with one exception. If you should have a jury trial and elect not to testify, the judge would instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you're presumed innocent of all of these charges till proven guilty by the state of Ohio on every essential element of each offense. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been indicted and accused of these crimes. In fact, under the law, you're not required to present any evidence in your defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of each of these offenses by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally, you entered a plea of not guilty. The not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment in each count that you're pleading to, admits that that is a crime, that you committed that crime. And that plea, as to those counts, waives, gives up all the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront the witnesses against you and cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives or gives up your right to, or your privilege against self-incrimination, because if you see your guilt, if you say you're guilty, then that's what's used to find you guilty. It waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court, and it waives, gives up any right to file an appeal that you may have had up to this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. That appeal will have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, sir.
Right now, do you have any questions about the charges that you're pleading guilty to or the possible penalties?
No, sir, Your Honor. I
Yep.
understand.
You understand those? All right. You have any questions about the plea agreement?
No, Your Honor.
You understand it?
I understand.
You understand that the matter of sentence is not a recommendation, and the recommendation on judicial release, if you are sentenced to prison, are not binding on the court.
Yes, Your Honor.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir, I understand.
Is there anything you'd like to speak with your attorney before we go any further?
No, sir. I think we're good.
You have any questions at all about anything that I've explained to you here today?
No, sir, Your Honor.
Then is it your decision to withdraw your not guilty plea and plead guilty to counts 1, 2, 3, 9, and 11 of the indictment pursuant to the terms of the plea agreement that I've just gone over with you? All right. Then as to the charge in count 1, which alleges that on or about June 1, 2023 through July 13, 2023 in Highland County, Ohio, you and Kate Rogers did receive, retain, or dispose of certain property, being a 2020 Chevrolet Equinox and motor vehicles, defined in ORC 4510.01, the property of B1, and that you and Caitlin Rogers, knowing or having reasonable cause to believe the property has been obtained through the commission of theft offense, the offense of receiving stolen property in violation of section 2913.51 of the Ohio Revised Code, a fourth-degree felony carrying possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty.
Count 2, which reads the same, except that the vehicle is a 1998 Honda Civic, and it is allegedly the property of V2. Otherwise, it's the same offense and the same penalties. How do you plead?
Guilty.
And then I'll go ahead and skip to count 11 first. Count 11, which is the same offense, except it is alleged to be a 1990 Honda CRX belonging to a V3. Otherwise, the same offense and the same penalty. How do you plead?
Guilty.
Then as to count 3, which alleges that on or about July 13, 2023, in Highland County, Ohio, you and Caitlin Rogers did prepare for shipment, ship, transport, deliver, prepare for distribution or distribute marijuana, a Schedule I controlled substance, an amount equal to or exceeding 200 grams, but less than 1,000 grams, when you and she knew or had reasonable cause to believe it was intended for sale or resale by yourselves or another, in violation of Section 2925.03A2, charge of trafficking of marijuana, third-degree felony carrying a prison term between 9 and 36 months, a fine of $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
And then as to count 9, which alleges that on or about July 13, 2023 in Highland County, Ohio, you and Caitlin Rogers had in your possession 12 items of property as listed in the indictment that I read earlier that are subject to forfeiture due to their instrumentality in the commission or facilitation of the offense as defined in ORC Section 2941.14.17, which would result in the loss of any interest you have in any of that property to the state. How do you plead?
Guilty.
All right, thank you. Court finds that on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. The plea is accepted and ordered filed. Defendant is found guilty of counts 1, 2, 3, 9, and 11 as charged. The remaining counts against this defendant are hereby dismissed. All right, since there is a joint recommendation regarding sentencing, I've also noted that the defendant has at least one prior felony incarceration, and I don't know if the 2020 offense in Franklin was a felony. Yeah, it says a felony, improper handling, but appears he got probation on that case. But in any event, the court is going to go ahead and proceed with sentencing. All right, Ms. Collins, anything on behalf of the state?
Thank you, Your Honor. We would note that the victims were consulted about this plea agreement prior to entering the same, and they did agree that this was an appropriate sentence. So we would ask the court to follow the same. We would ask for restitution to be ordered. In this case, $1,019.34 to victim 2, $762.49 to victim 1, and that the property be forfeited to the village of Greenfield for division according to the task force MOU. I have that in mind. Additionally, victims 1 and 2 are present and would like to address the court.
All right, before we get there, what was the amount of the marijuana, total amount? It's between 200 and 1,000. I'm just wondering what the more specific number alleged was.
I don't know. This file is actually a through reminder, and I don't have it with me, so I don't know if I'm going to be able to tell you.
All right, well, I'll go ahead and hear from the victims while you're looking for that information, Mr. Wagner. Thank you. You can be seated. All right, so the person identified as V1, I'll hear from you then. You will have to state your name for the record, please.
Okay, Devin Bryant is my name. I just wanted to say that, Dylan, you've got a whole life ahead of you, and none of this was worth making children scared of being home. You know, all of your actions, I don't think that you may have considered how it affects the kids in the situation, but my daughter wanted to go outside. And it doesn't seem that serious, you know, at the time. But I just hope that from here on out, you consider that your life can be completely different. You deserve to be safe at home as well, and so do my kids and her kids and everybody else involved. I just want you to know that you can make it happen. So let this sentence change your life. Okay?
All right, thank you. And then the victim identified as V2. And your name, please?
It's actually Rachel.
Go ahead.
Thought about what I wanted to say, and really a lot of it is what she said. The girl was an ugly a project for kids, and my son is intellectually disabled. He is down there, he would do things with his dad, and now he says, we gotta make sure, we gotta check the cameras, no one can steal our stuff. Do better. Kids shouldn't feel sad and afraid.
All right, anything further from the state then?
No, Your Honor.
All right, Mr. Wagner?
Your Honor, again, on behalf of my client, I apologize to you guys for your loss. I don't like your stuff, so I sincerely do apologize for that. Your Honor, we'd ask the court to go along with the recommendation. For what it's worth, again, maybe this is something more to speak about when the judicial time comes, when we file for it. Bill was at TCC, oftentimes, someone knows they're going to go to prison. I always have the hesitation or the fear, they're going to walk away from TCC, take off, have one last hurrah, or not show up in court. Dylan did check himself out at TCC last night, but he did show up here today. That gives me, I don't want to say some hope, that sounds like I have a negative connotation with Dylan, I don't. That gives me some relief that he is hopefully taking this serious. He knows we didn't show up here today, they've blown this whole deal out of the water. Hopefully he does the year without any tickets, and we file this judicial release, and the court will put him back in substance abuse. I know he was down at TCC for some time. I don't know if it was a run to counseling, so I don't go to prison. But even if it was that, he's here today, Your Honor. So he did show up like a man and take responsibility for his actions. That's all, sir.
Did you get the amount?
Did I?
Yeah.
236 grams.
Okay, thank you. All right, Mr. Rogers, anything you'd like to say?
Yes, Your Honor. I would like to sincerely apologize to the victim. At the time, I was under the influence of substances, and since then, I've gotten clean. I've been trying to do better for myself, and I'm sincerely sorry. I can't take it back, but I didn't mean to cause the issues I did. I wasn't thinking of the right state of mind, and I'm very sorry. That's all, Your Honor.
All right. Well, you were on quite a spree there. And in addition to stealing cars, you had a significant bulk amount of marijuana, but it also looks like you also had hashish, which is dismissed, and other drugs as well. And again, those were all in bulk amount. And the hashish and alprazolam are not drugs that we typically see people possessing. Normally it's fentanyl, heroin, meth, sometimes cocaine. Those are the drugs that we see people influenced by. And it's interesting that you didn't have any of those with you. That's why I wonder, well, you did have, it says you did have some fentanyl, so that was in count 12. But the other things, those are, and again, being bulk amounts, it certainly makes the court infer that you were dealing more than you were using and stealing. But, there's you're forfeiting a lot of property here as a result of these things, and you apparently owned real estate. And so, in addition to a lot of guns, none of which you were allowed to have. And it always concerns the court anytime I see somebody that's got large amounts of drugs and lots of guns and has prior convictions. Why are they accumulating the guns? And it just means that they're up to no good because you're not allowed to have them. It's not that you're a hunter or anything. You've got all these different types of firearms, and with the exception of the muzzle loader and the shotgun, none of those were hunting guns. Maybe the 5.56, that's a pretty big gun. I don't think we have any big game like that here. We need a 5.56. You're not hunting elephants or moose or anything like that. So again, it makes me concerned about what you really are. But given there is a substantial amount of time here, substantial forfeiture, and substantial restitution. So the court is going to follow the recommendation. So as to, it's ordered that as to count 1, you be sentenced to a term of 11 months, and I need the minimum, need the pretrial, on count 1, and 12 months on count 2, 12 months on count, 24 months on count 3, 12 months on count 11. Those sentences are ordered to be served consecutively to one another for a total of 59 months. Now, the court finds that consecutive sentence is appropriate in this case, since that is the joint recommendation. These offenses were committed as part of more than one series of conduct, different stolen cars, plus the possession of the drugs. And so it appears to court then that one single sentence would not adequately reflect the seriousness of the offense. The sentences that are being imposed are not disproportionate to the harm caused. The court further finds that the history of criminal conduct involving your past record as well as these numerous offenses is such that a consecutive sentence is necessary to protect the public. Then, according to the sheriff, you're arrested on March the 6th, is that correct?
Yes, Your Honor.
All right. Looks like you're released on March the 8th on bond, so you have 2 days of jail time credit. Now, upon completion of this sentence, it is possible the Adult Parole Authority may put you under post-release control for a period of up to 2 years. If they do, you'll be supervised on the terms they set by a parole officer. And if they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to 1/2 of your prison term, which would be 29.5 months for all violations. However, if you're convicted of a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, for whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. Now, it's ordered that you make restitution to victim 1 in the amount of $762.49, and victim 2 in the amount of $1,019.34. That's to be made jointly and severally with your co-defendant, Caitlin Rogers. Those payments will be made to the through the victim witness escrow account, and you'll pay any service fees that are charged for that service. And that order is a substantive order. What that means is that just because you serve your time, if you serve your entire sentence, that doesn't mean that you don't have to make restitution. That will continue as a substantive order of the court until it's paid in full, and that can be enforced after you even after the case is closed, if you do not make payments. And if you don't pay the restitution and you have the ability to do so, it could be enforced by contempt. Now, you're also ordered to pay the court costs, which judgment of grant and execution is ordered. If you fail to do that, then the clerk of courts can collect that through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, the court could permit you to do community service in this county and give you credit for each hour you work. Each hour you work will reduce your judgment by that amount until paid in full. Now, you won't be taken, you're going to be remanded to custody today, and you are hereby remanded to the sheriff for execution of your sentence. With regards to the judicial release, I'll say that don't file it any earlier than 12 months, because it's after 12 months incarceration. And I know sometimes it's filed early, but I don't want to file until after 12 months, and I'll look at it at that time. If I do grant it, most likely you're going to go to the Star CBCF, which is also a lockdown facility, and you'll remain in custody until that bed is available, and then you'll be required to successfully complete that along with other items. I will also notify the probation department to see if they can get an officer out there today or tomorrow to interview you to start the pre-sentence report, or I should say the post-sentence report for judicial release when it's filed. We'll set up for hearing. but only after 12 months. I won't set it any earlier than that. At that time, I'll make that decision. I'm not promising you I'm going to grant it, but if I do, that's going to be that's going to be one major condition, in addition to a number of others. But again, the decision will be made based upon the information that's submitted at that time, including your behavior in prison. Is there anything further from counsel?
Only that, and it's in the entry of the order of forfeiture.
Oh, I'm sorry. Yeah, all the property in count 9 is ordered to be forfeited as set forth in count 9, and it'll be to the agencies that you have included in the final judgment decree.
Yes.
All right. Or sentencing entry, I should say. All right. Anything further then?
No, sir.
All right. You have the entry?
Yes.
All right. You want to proceed?